do, because I think this will help you in, when you're answering an exam question, identify who's who, because a lot rides on you being able to figure out who's who, who's doing what, who's done what, who's who. I know it sounds very basic, but it's important, especially when I throw a question at you, it's an exam, and you're going to see these names of people, of DMs, adjudicators, referees, ministers, companies. It can be very confusing, and your job as a lawyer is to examine this whole story and pull out, okay, who's who and who does what, Very simple, but can be important, because if you dive in sort of in the middle, you're going to get confused and you're going to start calling someone who's not a DM, and you're going to get into trouble. So take a few minutes and figure out who's who. Who's who?
Well, the person that is basically the decision maker is the director, and the aggrieved party or the claimant.
Okay, stop there. Just one director.
Yeah.
Director of what? Who? What? Who's the director?
Isn't he the decision maker in the
Yeah. Yeah. Okay. Well, we'll start with Jill named the director. Who's the director?
Fair Wages Office, Policy Office.
Yeah. The director, the Fair Wages Policy Office. Yeah.
It's actually specifically
Investigator, kind of. Yeah. We had heard somebody say the minister. Minister, right? Minister of what?
Public Works.
Minister of Public Works, and what kind of label can we put on that person? DM. Good. Don't forget, this person is part of the ministry, right? And what's the relationship here?
I'm not sure I agree that the...
Isn't it the subordinate kind of relationship? The boss to the directors of
Yeah, so from the story, what does the director do with the minister?
It's a recommendation.
Yeah, report and recommendation from the director to the minister. But the minister is the one deciding, right? The minister is going to be the one to throw these people in jail and punish them, or not, or let them free. Keep going back to criminal, but basically, as we're talking about, they're the minister is going to bring down the ultimate punishment, or not. And what's the punishment again?
No bidding on contract
For
the government for 2 years.
For the government for 2 years. Yeah, 4. Yeah, 2 years. 2 years in the penalty box. We'll call it. You can't bid on government contracts for 2 years, so you're kind of like suspended. Yeah. So who else is involved here? Yeah, Magic Construction. MC Limited. Who are they? Like, what's their status, I guess, in this story?
The company is affected by the decision.
Yeah.
Decision making.
Yeah. What's maybe another word for that? Yeah, we can call them affected.
What is the complainant? Or she's the complainant or complainant?
But what's MC Limited is the affected what? What are they? Party, yeah, we usually use that term. Affected party, they're a party. Is there any other party?
Employees.
Yeah. Yeah, we have, how many?
2.
2 employees of MCL. What's another label we can put on them? Troublemakers. Complainants. Because they lodge complaints, right? So they're complainants. Is there anyone else in the story?
The spouse of
Yeah.
one of the employees.
Yeah, but that's in here, yeah.
Yeah, there's the spouse of the person.
The spouse somehow is brought into the story. Spouse of who?
One of the employees.
Spouse of
One of the
the employee.
She's one of the 6 people that work at the administration. So she's
Yeah.
part of it.
Works at
Yeah.
which part of the ministry?
One of social minister of work. Public works.
Minister of Public Works.
Right. Works at ministry. So somehow we know that person's potentially important.
Yeah.
Otherwise, they wouldn't have been mentioned. Okay, is there anyone we're missing?
Law firm?
Yeah. Yeah. And who's the law firm representing?
The company. I'm saying.
Yeah. Law firm for NCL. And who are you? Who are you? You're an articling student at the law firm that represents the company. You guys are the company, right? Effectively. Okay. So you're gonna go to court. You're gonna go to court, and you're gonna stand up, and you're gonna say, "This whole proceeding was unfair. It stinks." Okay, I'll be the judge. You get up, you tell me it was unfair, there was all these procedural fairness problems. What am I going to say back to you? What am I going to say back to you? If you start off, the first thing you do, you get up on your feet, this was unfair. What am I going to say back to you as the judge?
Indicate to me exactly how and in what way it was unfair. Show me.
Yeah, but even more fundamental,
Whether there is a treatment for procedural fairness.
yeah, no, you're right.
Oh.
In our framework, is our duty at all, but really, we're skipping over that for this purpose because we said we're going to jump into Baker.
What is the
I'm going
level?
to say,
What is the level of procedural?
yeah, what if, I don't want to hear it. Stop. How much procedural fairness do you say this DM owes your client? Articling student. And you're going to say what? You're going to say,
We have to go through the test.
yeah, let me go through the Baker test, Your Honor. Let me go through the Baker test, and I'm going to tell you where I think it goes. Literally, they're going to say, okay, do the Baker dance for me. Do the Baker test. You say that procedural fairness is owed. Well, how much? Is it low, medium, or high? I'm going to say to you. And you're going to say, well, I don't know. So you're going to say, okay, I will walk you through the factors. And I will take you to where I think it should go. To low, medium, or high. So, And I'm making this point because they don't want to hear about your complaints yet. Yeah, they say park that. We'll get to that. I know you have like 50 complaints about lack of procedural fairness, but let's start with Baker because I'm the judge and I need to know that too. You're probably going to tell me it's medium or high. The lawyer on the other side is going to say it's low. Probably. So you guys are going to be fighting about that. So you're going to use Baker to make the best argument you can, but you're going to be fair and balanced in how you apply Baker. You're not going to say this is the ultimate, everything points to more fairness. No, you've got to be reasonable about that and not, reach for the moon and the stars. Okay, so what's the first Baker factor? Yeah, exactly. Nature of the decision. And what do we look at here again?
If it's like law and order or not.
Exactly. Does it look like what we see on TV? Does it look like a court? Does it look and quack like a duck? Does it look like a court? What do you guys say here?
But it's not totally different.
Give me a factor, somebody give me a factor that points to, I guess our whole group thing is falling apart. But somebody give me a factor that makes this hearing, so-called hearing, look like a court. Good. Evidence. What evidence did we have here?
Complaint, and then, so submission from the complainant, the complaint herself, the submission of wage and company. which is-
Evidence, wages, yeah, no, you're onto something there too. Sorry, you said there was a complaint.
Yeah.
There's a complaint, which is usually a court case, starts with a complaint. Could be the police complaining that somebody committed a crime, or obviously that's not what we're talking about here, but there's a complaint that triggered, and it triggered what?
Investigation.
Yeah. Investigation. Although investigation, is that what court? I can't spell. Is that what courts do? Yeah, not so much. But there was an investigation, not terribly helpful. Is there anything else that looks like a court? You guys are missing something. So, yeah, evidence. But what did the director do?
There is a
Ask for evidence. Let me see those wage records.
There's a bit of an investigation.
Sorry, I can't hear you.
No, it's okay.
What did-
I'm sorry.
Okay. What did the director do with the evidence?
Evaluated it.
He wrote a report with a recommendation,
Evaluated and,
and he issued a recommendation to the judge, to the minister.
yeah, recommendation. Not so helpful. That doesn't look like law and order. But what does look like? What did the director do? They don't really describe it, but what did the director got evidence and did what with it?
And we'll issue the
Examined it, evaluated it. But what's the key thing?
The copy of the report to the
Disqualification order?
No, it's not obvious, but it's implied.
Found an outcome that concluded with the
Made findings of, you're close. Fact finding. Well, that looks like a court. There's no courts make factual findings. judges do, courts do. What else? What did the director do with those facts? I know it doesn't scream out at you, but it's implied, and when you hear it, you'll say, yeah. What did they do with those facts? No. Based on what? What did they do with the facts?
They came to a conclusion.
Yeah, you're all so close, but you're just missing. You're missing.
They made a
The
decision.
director applied the facts to what? No. No.
To the law, to the regulation?
Who said law? Yay. Applied facts to law. That's what courts do. Apply the facts to law. Now, it's a bit sneaky because they don't tell you that, but of course, they looked at the facts, they said, oh, the law says, you have to have fair wages, so they did an evaluation of it. Based on these facts and these records, and based on the law, this was an unfair wage. These are unfair wages for these two people. So it's a factual finding and findings of law based on the facts. That's what courts do. Okay? So there's stuff there, not great. And let's talk about what's missing. What's missing from a court?
No adversarial parts.
Yeah,
No written part.
no adversarial process. No, sorry,
No witness.
no witness.
No hearing. No hearing. Nothing.
Yeah, no in-person hearing.
No gross crimination.
What people are missing? Our favorite people, kind of people? Lawyers? No lawyers? So there's quite a lot missing. That says this isn't very much like a TV trial on Law and Order. So yeah, very good. You guys got it.
So it'll be like sideways. Because there's some and
Yeah. Right. So good. Thank you. So we have to get an arrow out of this, right? We need an arrow. Which way's the arrow going?
what was happening?
You put sideways. Okay. That's not bad. That's not bad. I'm okay with that. Maybe everybody else. I thought you could have an arrow up.
Really?
A small arrow up. So here's a little arrow up. It's a little bit, the findings of fact and law, applying facts to law, that's something, and that's pretty important. Don't worry, that's not easy to know where the arrow goes, because it's quite mushy, because there's some stuff here, there's a lot missing. If you put sideways, that would probably be acceptable. I thought a little bit up. In fact, some people might even say a little bit down. They'd say, wow, look at all the elements that are missing. It really, to me, doesn't look like a court if you put an arrow down. Actually, that would be reasonable. So sorry, but it's not so clean, not so easy, but at least what matters is this, doing this.
So are there some factors that weigh more than others, or are they all equal?
The courts don't tell us. We can't say which ones are heavier or lighter. So do your best, is all I can say. What's more important than getting the exact right arrow is saying, I know what's there that looks like a court, and I know what's missing. And then you tell me what you think of that. I'm okay with it if you say the direction of an arrow that I don't necessarily personally agree with, that's okay.
So, but if there is backfiring and applying fast to the wall, then you think it's not.
It's got some strength, a fair bit of strength to it, but yeah. Yeah, okay. So you get the game, right? This is the game. No matter what, you're going to be able to say, okay, does this look like a court? And you've got this list. We've looked at it before of what looks like a court and what doesn't. So that's what I want you to do. What's there, what's missing. There may be nothing missing. Be very court-like. But usually there's going to be something where you go, oh, there's something missing here that doesn't look like a court. So that's going to push it down towards less fairness. So we got either neutral impact, a little bit up towards more fairness, possibly even a little bit of an arrow down. But it's not it's not a big arrow down. Okay. What's the second factor?
Statutory services.
Yeah. Nature, stat, scheme. And what's sort of the key element here? The key phrase that I mentioned, you may not remember, something to do with a road. Is it the end of the road under the statute? Is it the end of the road? Procedurally, is it the end of the road? Does MCL have any more procedure ahead of them? Steps they can take?
Based on the fact that we know that the final decision will be rendered by the minister, but we don't know the options after the final decision. So we know that I'm assuming that.
What options do they have? Do they have any options based on the story we told you? No, they have no options. They're sitting there waiting for the judge to bring the hammer down and say guilty or not guilty. It's procedurally, it's the end of the road. There's nothing left. They didn't say, "Oh, you can appeal the minister's decision." They didn't tell you anything. So the only conclusion you can come to is it's the end of the road. Under the statute, procedurally, it's the end of the road. Of course, we know a decision hasn't come yet from the minister. The minister hasn't made a decision, but procedurally speaking, there's no more procedure left. It's finished. It's as if there's been a whole hearing, and the judge just says, I'm reserving my decision. You'll get your decision when you get it. It could be a week or a month or a year. We have no idea. But it's the end of the road. There's no more procedure. You can't go running back to the judge. It's finished. If you as MCL, write a letter to the minister, they're going to throw it in the garbage. Like, no, there's no procedure. You don't have the right to make submissions or do anything. It's the end of the road in the statute. So what does that mean for the arrow? Yeah. A good, solid arrow up. It's an arrow up, more fairness, end of the road. Right? There's nowhere else to go. Procedure. Okay, so that was pretty straightforward. Factor 3. What's factor 3? Yeah. We like this one, right? Importance, decision to the minister.
To the affected party,
Who?
Magic construction.
Yeah. Importance of a decision to your client, Magic Construction. What are you going to tell me? Don't just give me an arrow. You got to, make your case.
If you can't bid on projects, then you are going to take a hit to your business and bottom line, and you might have to let go of some employees. Sometimes jobs could be found.
Very good. Do we know any of that, though? Or did you just make that up?
Both.
You just made that up because you're a good lawyer. But do we know that in fact this is going to have a major impact on MCL's interests
Yes, we do know that.
or rights? Do we know?
Yeah.
Yeah, sure, you're supposed to be able to make a bit.
Well, at the time,
What if they don't care? What if they don't care?
They were engaged into construction to permit arenas for the.
Yeah.
So it will have an impact on their.
Well, we're looking at future. How do we know?
But if it's the only two contracts they have, then we can assume that that's the source of their.
Okay, I'll play devil's advocate. What if they've been in business for 20 years, they've never done federal work for the federal government. They got these two contracts, yay, they built the two rinks. But as far as they're concerned, they don't care because they've got more construction business than they can handle in the private sector.
Then
I feel like they see the.
But-
I'm just undermining you.
But based on the facts, I think they got pretty concerned. Like they argued that if they had the opportunity to speak, they would.
Yeah, they would have defended themselves.
They would explain like
Yeah.
what happened, and they would provide arguments, and
Yeah.
they were upset that it was the end of the process. So.
Yeah, no, that's very good. So there's some hints here that they actually do care, and my theory about, they don't care, big yawn. They probably do care. Somebody else?
Yeah, just to that point, if you went to a lawyer.
They went to a lawyer, yes.
Indicates they're desperate.
Yeah, they're willing to pay a lawyer. Yeah, no, you're right. They're willing to spend money because obviously they're worried about losing money. Why would they spend money otherwise? Just not on principle? No.
On the facts of it, losing business for 2 years is a big deal. And also I believe
Well, it can be.
potentially, and also I believe that I think it's the onus is just on the other party to prove that they don't have any interest in this and it's not a very big deal for them.
Yeah, the other side's probably going to say, yeah, it's probably not a big deal for them. Right, let them prove why they care so much. Or why, are they going to lose like millions of dollars or not? But, there's an argument here, right? But I think the people who are leaning towards, yes, this is going to have a financial impact, I think have a little bit better argument. Because they do seem to care. Going to a lawyer right there is telling you something.
So if it's about them caring, what about the guy with the voting license? If he should demonstrate that he cared about it and hired a lawyer.
Yeah, care maybe is a loose word I'm using. Care as in it's going to hurt me.
So financial.
It's going to hurt me how? Reputation, finance. Oh, I just blew a really good argument. I was going to ask you if you thought about the reputational damage. What about reputational damage?
More about
It
damage.
probably in the news that this
So not just
company was just banned
Yeah.
from participating. in
MCL
public
construction,
tender.
hates women. Being extreme, but reputational damage in the industry. It's going to get out there. Let's assume the Globe is going to publish an article on this about how terrible this company is. Bad corporate citizens. They underpay their female employees. So you got a reputational problem there. So you guys, get creative. What is the real world impact beyond money? Money obviously is front and center, but there's other impacts.
I just had an aha moment.
It's a-
Let's suppose this is not magic construction. Let's suppose it's SNC level and is not allowed to bid on any federal contracts. I mean, there's a real life example of
corruption of some kind.
yeah, and their reputation and all of that, but it's the same thing, because SNC was not allowed to, or had they, whatever, had they been taken down the road that they should have been, then they wouldn't be allowed to go on any federal construction
Yeah.
contracts.
Yeah. So you room to get creative. They've given you some hints. But, they write this in a way that's like arguable both ways, right? So don't jump to a conclusion and make an assumption, oh, they're going to lose millions of dollars, because the other side's going to go at you on that and say, what are you talking about? This, how do we even know that's true, right? They're going to try to, to push back on you because they want a down arrow, right? They want a down arrow. You want an up arrow for MCL. But I would say on balance, there's a pretty strong argument of an up arrow. But what I want you guys to do, as any good lawyer, you will recognize the weakness of your case. So here you would say, a good answer would be, I think there's going to be financial harm, although it's not totally clear, the extent of that, because we don't totally know that they rely on federal government contracts for their survival. So are they going to go bankrupt, or are they going to be like, oh, that's a bummer, I guess we better go, get some private sector business, and maybe they don't even lose $1 for all we know. But there's a reputational piece, which I think is actually quite good, because that's a great comeback to, oh, who cares, this is no big deal. Well, it is. Reputationally, which of course in itself can cause financial harm. So you've got something here, and I think you've got an up arrow. But some of you might point, as I was saying, point out that weakness and recognize it if you're really being objective about the test. Okay. On to number 4. What was number 4 again? Yeah. Fall short form, legitimate expectations. What are we looking for here? Promise. Promise of a procedure, pretty much, by way of 2 ways. How is it promise communicated?
It should be expressed by
Expressed out of their, I say, out of their mouth. They spoke it. Maybe in an email, but they spoke it. Or a letter, or an email, or literally speaking it. Do you guys see anything like that? No. Do you see anything like conduct? Remember we talked about conduct. You continually grant procedural rights, like an oral hearing, and then suddenly they don't give it to you. Do we have anything on here? No, we have no history. So where does the arrow go here? Sideways? Yeah. We have nothing. And, most cases are going to be like that. There's going to be nothing. But watch out for that, because anytime you see anything like that in terms of a promise of procedure, you have something, and it can be very powerful to win the day. Too bad for us, we don't have it here.
I was just wondering, can it not be a downward arrow because of their lack of any evidence in that area?
No, it's not a downward arrow. It's because we just have a lack of evidence of any kind of promise. So it doesn't bring the fairness down, it has a neutral impact.
Question, couldn't, the statute is silent, can't it be read in? Because, again, we've got a test question, there's only 1 page, it's not like,
Yeah.
not all the details, but
Right.
in this, it doesn't appear that the statute says anything about how conflict.
No, they've told you nothing.
Yeah, so
Next to nothing about procedure, just a little bit. So we don't have anything.
on an exam, if somebody threw it out, chance that statute, they'd read it in, but you
No.
don't care.
No. Okay, what's our 5th and final factor?
Procedural choices. Decision making.
Yeah. So we're showing deference. In this factor, we're showing deference, procedural choices, and decision making. And there's that quote that says, especially when,
When there's a lot of statutory discretion.
when there's a lot of discretion shown in the statute, when it's kind of wide open. We don't really know here. We don't really know But you can always rely on the fact that there's going to be some degree of deference to the decision maker's choice of procedure, right? That's a given. So which way is the arrow pretty much always going to go?
Now.
Yeah. We don't know a whole lot about the statute. If we did, we would look at that and say, well, did the legislature give them lots of leeway, discretion to choose their procedure, or did they dictate, step, 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 lots of procedure, which suggests the arrow doesn't go down very much. Okay. So, very good, guys. So what do we have here? We've got like sideways or little up arrow, pretty good up arrow, good up arrow, sideways, and a down. What do we make of that overall?
Well, at least medium, at least.
Yeah, I think you guys have made a good guess in terms of suggesting that this looks like medium. Why not high? What would, if you picked high, what would be the criticism? Yeah.
It's not like, and even the two errors, like the one that is how much it impacts the person, there is also like the other side, which we're not even sure how much it might impact them.
Yeah. So there's considerable doubt here, and we know this can, very hard to equate this with the most serious of cases, like immigration cases, or cases where clearly, well, let's take the ability to practice your profession, right? We know some of those are going to get high. Can we equate that? Hard. Maybe you can make a case, but it doesn't seem like we can justify a high outcome with the way our arrows are looking. What about low? Looks to me, it looks like it's going to be a fight between medium and low. The other side is going to take a shot at low, but probably my sense is most courts would say, yeah, we're looking at medium. It's a serious penalty of a 2-year ban. Well, there's still this doubt about what does that really mean for them, but on the face of it, it looks like a serious penalty, right?
Shouldn't the big pronouncers be also more abstract?
Abstract. Isn't it abstract already?
Yeah.
Yeah, no, this is difficult, and I know this perplexes students because you're like, well, how am I supposed to know? But you look at the arrows and you make your own judgment call, and as you look through the cases, we're getting a sense of what we think is fair and appropriate. What's most important is that you take a stand. A lot of people just gloss it over. They don't even give me a conclusion. This happens. You guys are not going to forget that. You're going to remember to give me a low, medium, or high, and support it. Say something. Don't simply say, I've looked at my arrows and I think it's medium. You're going to have to remember, I'm the judge, and I'm going to say, why? Why medium? Why did you get there? Tell me. And don't just say, well, look at what I did. I did all this work, and that means medium. Well, the judge is going to say, yeah, that's not good enough. I need better than that. It could just be a couple of lines to explain, and you guys have already just told me now why you think, most of you think it's medium. Yeah, so kind of do somewhat of an evaluation to support your low, medium, or high, and then you're good. Okay. This is the most important part. I didn't want you to do a heavy-duty analysis on the actual PF issues, PF complaints, but we know that now that we've done this, our job is to identify, okay, what are your procedural benefits that you claim you didn't get? What Mandarin menu items did you not get? Can we just identify them without doing a full analysis? Maybe we can do that in another class, a full analysis. But for tonight,
Chance to respond.
Notice.
Notice.
yeah, notice is a biggie. What was the failure there? Again, we're MCL, we're complaining. What was the failure? What did MCL not get notice of?
That a complaint had been made and that the decision was in the process of being made or had been made. So they never had a chance to respond to the first or the second complaint.
Yeah, they didn't seem to get proper notice of the complaints. And of what else?
Of the investigation.
Yeah, good. They didn't get proper notice of the investigation. There's something else major they didn't get notice of. Of the recommendation?
Of the first violation?
Yeah, well, yeah, of the recommendation.
I mean, in an ideal situation,
There's one, sir?
in an ideal situation, the director should have sent them a notice saying that he's going to recommend the ministry the disqualification.
Or may recommend, right? Early on. Oh, I'm doing this investigation. I might recommend what?
2 years ago.
Yeah. So there was a lack of notice of penalty. Huge. Courts really don't like that. They really don't like that when you fail to tell a party, well, by the way, we might put you in jail. It's kind of important at the earliest opportunity, and we understand that from our sense of fairness. Hey, MCL, you might be hit with a 2-year ban. We're not there yet, but you might be hit with a 2-year ban from the minister. So you got to tell that MCL that is possibly going to hit you, right? So that's huge. Really good, really good. So there's a lack of notice. Somebody else mentions a second type of problem. What's the other, like, really big procedural fairness benefit?
Reasons.
Response?
Maybe. Let's park that.
Response? Like, obviously,
Opportunity
you need
to-
a notice to have a response.
Opportunity
Hearing, I would
Hearing.
also part them.
to be heard.
Yeah, to be heard.
Opportunity to be heard. Yeah.
Come on, let's have some more minds.
Opportunity to be heard, yes, huge one. It's almost, I mean, it's like the most important thing. Did they have the opportunity to say, 2 violations, what are you talking about? There weren't 2 violations, right? There's that issue. It's not really 2, it's really 1, right? There's that argument. They had no ability, the director didn't say, hey, MCL, what do you guys think? Should I recommend a ban or no? I'll give you 30 days to, say your case, tell me what you want to tell me, make submissions, or I'll invite you in, you can come talk to me, or whatever. No opportunity to be heard, huge. And there's another one. That is very relevant to what we talked about tonight. Before. RAOB, yes. Because of this whole spouse business. RAOB. Spouse. Complainant in Minister's office, right?
I have a question. So this reasonable apprehension of bias, does it falls within the procedural benefits, or is it separate concept? Why would you mention it under the procedural benefits?
You could call it another benefit, but it's its own separate category. Remember, if there's a duty of procedural fairness, you have the right to be heard and the right to an unbiased decision maker. So it's under right to an unbiased decision maker. Right to be heard is the Mandarin mandate.
Yeah.
But it's just categorization. It's another procedural benefit. Is you have a right to an unbiased decision maker. And they can say that it's another procedural complaint, fairness complaint. And that one is probably not that easy to analyze, but we kind of get it. We're getting a sense there's something there. Right?
Can we come up with two factors, the relationship between the spouse and the employee and the monetary interest, because that's about to be.
Very good. Yeah. Is there a monetary or pecuniary interest here that if there's a certain outcome, there's going to be a benefit to somebody in the minister's office? It's kind of,
I don't see it.
you have to connect some dots here. It's not very obvious, but there's something there maybe to argue.
But if
You
there's only
think it's not?
I don't see it, no.
If there's only 6
I'm not so sure.
employees in the minister's
Yeah, it's a small office, and
and she obviously could affect the decision, right? And if we're going back to this test on a reasonable person,
Yeah.
if we ask somebody on the street,
let's go down right now and ask somebody who's about to get on the subway, tell them the story, and they're going to think we're crazy.
There's a
Yeah.
perception on police.
Yeah.
Some clever person thought this up and thought, I'm going to come up with a, kind of a gray area REOB. They never make it easy. Right? It'd be too easy. So they're giving you some ammunition here, but it's kind of weak. Not super strong, but there may be something there. There may be something there, and it could, it causes you to stop and at least stop and think about what's happening here. Does it meet the threshold? I don't know. We probably have split opinions in here.
we just.
Some people didn't like the, where's the money? Follow the money. She's going to get a raise, right?
No, she's getting what's fair.
Maybe? No, you don't.
She's getting what's fair,
Getting what's fair.
right?
Yeah, okay. That's not like a windfall. It's not like, I get all this money.
There's
It's like
something
she's just getting
illegitimate.
what she's entitled to.
Exactly. There's something
Yeah, and they've been
illegitimate.
violating by underpaying, so, is that really a monetary benefit? That's a good point. Yeah, so, they've given us something to argue about and think about. So that's really it. Like that is, what we went through here is really the way you should tackle any procedural fairness problem, obviously with Baker. Of course, you may have to decide if there's any PF owed at all. That wasn't really what was going on here. So just depending on the question, I'm not out to trick you. So if I ask you a question, and on the midterm, I just say do a Baker analysis. So that means don't do the night 3-prong test. Is it duty owed to column one? Don't bother with that. Go straight to Baker. I almost said that. Go straight to Baker. Do this. Okay. If you want to take pictures, if you find it of any use, please go ahead. But I think we're gonna call it a night. Good work tonight. Thanks for hanging in there. Still got you in a little bit early. We meet again next week, of course. And you can ask me questions about the midterm then.